What happens if your spouse dies and had created a will before you were married, but left you out of the will? If your husband's or wife's will was made before your marriage, the omitted spouse statute may be the solution to claiming your inheritance. The law in New Jersey provides relief to an omitted spouse of a deceased testator in New Jersey. In situations in which a spouse fails to provide for her surviving spouse or domestic partner, and the spouse married the testator before the execution of the testator's will, the omitted spouse is entitled to the intestate share. The intestate share means the share you would receive by law if your spouse had died without any will. There are exceptions that other beneficiaries may raise to your omitted spouse claim. The omitted spouse rule does not apply if, 1, it appears from the will or other evidence that the will was made in contemplation of the testator's marriage to the surviving spouse, or in contemplation of the testator's formation of a domestic partnership with the domestic partner. Number 2, the will expresses the intention that it is to be effective notwithstanding any subsequent marriage or domestic partnership. Or 3, the testator provided for the spouse or spouse by transfer outside the will, and the intent that the transfer be in lieu of a testamentary provision shown in the testator's statements or some reasonably inferred statement made from the amount of the transfer seen in the assets. You may also claim under the elective share statute in addition to the omitted spouse statute. If a spouse or domestic partnership dies domiciled in New Jersey, the surviving spouse has a right of election to take an elective share of 1/3 of his or her spouse's augmented estate. The surviving spouse must elect to take the elective share by filing a complaint within the court 6 months after the appointment of a personal representative of the decedent's estate. The election is allowed under the limitations and conditions that at the time of death, the decedent and the surviving domestic partner had not been living separate and apart in different habitations or had not ceased to cohabit. I know probate law can be very complicated, so it's important to give us a call to protect your rights under the elective share or omitted spouse statute. We would love to meet with you and help educate your family and protect your assets.